Hey guys, it's Kathy. I hope you're doing well. Oh, I got some stuff for you today. Man, oh man, oh man. I did sneak onto YouTube and get one thing for today, but the rest is just not from YouTube at all. That being said, the first one I have, um, it wasn't WebEx or a Zoom or a YouTube. I think it was the courtroom that had technical difficulties, because everything else I was doing was perfectly fine all day. But the video froze, and there was nothing I could do. It's live. I couldn't record. I can't rewind or anything, so I couldn't do anything. The audio was fine, but the video froze. But the audio is great. And I have to give you the backstory because I didn't put the entire trial here. It was too sad. So keep that in mind. It's so sad. It was a murder trial. And they had, almost everybody from the family came up and spoke. It wasn't just, the husband or the father. It was cousins and everybody came up and spoke. And the defendant, showed zero remorse or anything during the whole trial. So we just got through with closing arguments, all right? Now, the way the trial started was the judge said, everybody in the audience needs to just calm down. Because if I hear anything, you're out of here. And she says, I don't want to do that to you. I know that you want to be here at this trial. I know you want to see this sentencing. But I can't have you guys continue to fight. So the convict's parents were there, and they were fighting with the murdered woman's family and everything. You have to remember that part because I think that's why whatever happened happened. The dad of the murderer left because he wanted to be there to support his son, but the other family was not having it. Period. So we just got done with the closing arguments, and now the judge is going to begin her sentence. And it's not funny. This is a very serious, sad thing.
Let me first say I appreciate everybody that has come today and who has spoken and who participated in the trial, and especially the jurors. I do know that our system puts
May I have your attention, please? May I have your attention, please? A fire has been reported in the building. A fire has been reported in the building. Please proceed to the stairway.
Let me just say, generally, those are
Use
nothing.
the elevators. May I have your attention, please? May I have your attention, please? A fire has been reported in the building. A fire has been reported in the building. Please proceed to the stairway and exit the building.
That'd be great. Thank you very much. As I say, generally, those are false alarms, and I've just had that confirmed, so please disregard that. As I was saying, our system puts a large burden on ordinary citizens that we call in to make decisions of this magnitude. And I don't take lightly the fact that I'm called upon to make a decision concerning.
May I have your attention, please? May I have your attention, please? A fire has been reported in the building. A fire has been reported in the building. Please proceed to the stairway and exit the building. Do not use the elevators. May I have your attention, please?
Hard to believe it's coincidence, right? When I get the stage, this happens.
It is very hard to believe. Yes, Judge.
Please proceed to the stairway and exit the building. Do not use the elevators. May I have your attention, please? May I have your attention, please? A fire has
Can
been
that be
reported
turned
in the
off?
building. A
They
fire
do
has been
fix it.
reported
Don't
in
worry.
the building. Please proceed to the stairway and exit the building. Do not use the elevators. May I
That's
please.
horrible.
May I have your attention,
They do
please?
turn it off. They
A
do
fire
turn it
has
off.
been reported in the building. A fire has been reported in the building. Please proceed to the stairway and exit the building. Do not use the elevators. May I have your attention, please? May I have your attention, please? A fire has been reported.
The judge is getting
in the
really
building.
angry. There, they got it.
All right. As I was saying, I don't take it lightly, the responsibility that the state places on me. And in particular, when I'm dealing with, a young man. However, that being said, age is the only thing that is mitigating with the defendant. I mean, he took the life of a young and promising mother, wife, sister, daughter, niece, cousin, friend,
He's 24.
for no apparent reason. He has shown no remorse. He's been devoid of emotion. As a matter of fact,
May I have your attention, please? May I have your attention, please? A fire has been reported in the building.
if they could turn that off, have them turn it off. He's been devoid of anything. I mean, at the scene, he was described by the officers as calm, which is a frightening thing to me under the circumstances. I mean, especially, he's got the deceased woman that he's just drugged and dumped under a tree right there at his door with her phone in his pocket, and he's calm.
May I have your attention, please? May I have your attention, please? A fire has been reported in
I mean, that fact, in addition to the just total disregard and lack of respect for human life that was shown in the way that he treated the body. And, I don't know how we were blessed with that camera being pointed directly at the door of his
May I have
apartment.
your attention, please? May I have your attention, please? A fire has been reported in the building.
Or we would not have known all of the facts and circumstances in this case. But we do know it. And we saw it. And, I've heard from three statements from three living survivors of similar acts that didn't go to this extreme. And he's only 24 years old. And, that to me is an indication of a depraved heart. I don't know any other way to put it. And while I can't impose an eye for an eye, I can assure that basically he'll have no good days before him. And on malice murder, I'm going to sentence him and order him into the custody of the Department of Corrections to serve the remainder of his life without the possibility of parole. I don't think I have to do anything further. I think that both 2 and 3 would.
Count 2 is vacated as a matter of law, and I think
Right.
count 3 merges into count 1.
Right,
Yes, ma'am.
would be irrelevant at that point, and there'd be no terms and conditions of anything possible short of that. And Mr. Dryden, you know, I don't take pleasure in it. But that's my sentence. Do you have any questions?
Not right now.
All right. Thank you. You may be excused.
Yeah, that was horrible. Horrible. I mean, I'm sure it was a. She lost her train of thought a couple times, as would everybody, anybody. And she was on great paths, you know, it was riveting. We were listening to her, and the stupid fire alarm just killed everything there. That was down in Georgia. That's what kind of day they had down in Georgia. I think, and I could be wrong, but I think someone pulled the fire alarm before sentencing. But anyway, let's go to Indiana. Hold on, sorry, 1 second. So this is a WebEx, and if you remember, the longer a WebEx goes, the more the audio detaches from the video. Um, and this one, I don't think I tried to fix at all. I just ran out of time. I have 3 little clips from this judge, and the other 2 I tried to fix it the best I could. But this one I think is like 5 hours in. It was a 9-hour docket, so the audio and the video don't match perfectly on this. Don't even match close on this one.
Thank you, Ms. Faulkner. How about Star Hodges? Star
I'm
Hodges.
here, Your Honor. I'm here, Your Honor.
There we go. Hang on a minute. Twenty CL 1602 F26, State of Indiana versus Star A. Hodges. Raise your right hand, please. You swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yes, Your Honor.
State your name for the record.
Star Ann Hodges.
Show the defendant appears in person from the Elkhart County Correctional Facility as a self-represented litigant via WebEx, State of Indiana in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. This matter comes on for hearing on an alleged violation of Michiana Community Corrections. No, it's not coming up. Come on. There we go. The purpose of this hearing is to inform you of the allegations against you and what your legal rights are. If you do not understand your charge of your rights, please let me know and I will explain them more fully. You have the right to have an attorney represent you if you want an attorney to represent you, but cannot afford one. The court will appoint an attorney for you if you qualify, but you should request the court to do so as soon as possible. If you choose to deny the allegations, you have the right to have an evidentiary hearing, which is a trial. At this hearing, the state would have to prove one or more of the allegations by preponderance of the evidence. You would have the right to confront and cross-examine the witnesses against you. You would also have the right to subpoena witnesses at no cost to testify on your behalf. At your evidentiary hearing, you cannot be compelled to testify against yourself regarding any allegation that you've committed a new criminal offense because you have the right to remain silent regarding a new criminal offense. As to all other allegations, however, you may be placed under oath and called to give testimony against yourself. You have the right to appeal the court's decision if the court finds that you violated your placement in community corrections after an evidentiary hearing. If the court finds that you failed to comply with the conditions of your placement in community corrections, it may change the terms of your placement, continue your placement, or revoke the placement and commit you to the Department of Correction for the remainder of your sentence. Do you understand your rights as I've just explained them to you?
Yes, Your Honor.
Okay, this was filed against you on February 16, 2024, and it alleges that on February 1, you tested positive for synthetic cannabinoids on a drug screen. It also alleges that you were to contact Oakland, and as of February 15, 2024, you failed to do so, and that you had not been to your NAAA meetings. It alleges that you failed to obtain employment. I'm kind of summarizing some of these. In any event, do you understand the allegations which you face?
Yes, Your Honor.
Do you intend to hire private counsel, or do you want me to appoint the public defender's office?
I don't wish to have counsel, Your Honor.
Okay, that is a very bad
Great
idea.
idea. Great.
Ms. Hodges.
Great idea.
That is a very bad idea. Now, the Supreme Court says if you don't want to have an attorney, I have to let you go forward without one, but I'm telling you that is a very bad idea.
Great idea.
Do you want me to appoint the public defender to represent you, or do you want to represent yourself?
I would like to represent myself, Your Honor.
Okay, do you have any specialized training in the law?
No, I don't, Your Honor.
Law and
Do you know the
order.
rules of evidence? Do you know the rules of trial procedure?
Yes, I do, Your Honor.
What's the burden of proof in this case?
Well, I was attending AA meetings online in the room.
That's a legal question, and you didn't
Oh,
answer.
I don't.
Everyone watching knows that answer. Everyone watching could have answered that. Now we all think, hey, we could be our own lawyer because we passed his test, even though she failed it. But we can't.
Which clearly shows me you don't understand what I'm saying. That's why I'm telling you ought to have counsel. Let's keep going. What experience do you have in handling legal matters in court?
Well, Your Honor, I just want to get this over with. Whatever it is, I'm ready.
Again, that is a bad reason to represent yourself. Ms. Hodges, I can't stop you from doing this if you're bound and determined to do it. Do you want to go forward and represent yourself? This could be a very, very bad decision.
Okay, I'll take counsel.
You want me to appoint the public defender's office?
Yeah.
Okay. Let's see if you qualify. Do you own any land, like a house?
No, sir.
Do you have any cash, any bank accounts, any investment accounts?
No, Your Honor.
Do you have a car, any personal property that you could sell?
No, Your Honor.
Are you currently employed?
No, Your Honor.
Court finds the defendant to be indigent. Public defender's office appointed to represent the defendant. Are you on a no bond hold?
I don't know. I don't know anything right now.
Yeah, the answer to that is yes. Would you like me to consider a bond?
Yes, sir.
Court orders probation to prepare and file with the court a written bond report. Court will set this matter for hearing on bond upon receipt of that report.
Your Honor, if I may.
Mr. Johnson wants to talk. He's a public defender who is in my court more than anybody else right now. I'm gonna let him talk, even though he has not entered an appearance yet. Okay with you, Ms. Hodges?
Yes, Your Honor.
Go ahead.
It looks to me like this is an MCC violation, so it may help to expedite things if we get ECC and MCC evaluations.
Good idea. I'm gonna say something else. Counsel, both sides, I'm not saying anything to forecast anything. I'm just making a suggestion. I think we ought to set this for hearing March 21,
Okay.
2024. You okay with that?
Yes.
Because I think she needs to come back sooner as opposed to later.
Absolutely.
Hey, Ms. Hodges,
Yes, Your Honor.
either Mr. Johnson or somebody from his office will come out to see you in the next week or 2 weeks probably, okay?
Okay.
To get ready for this March 21 hearing date. You hang in there, all right?
Your Honor, can I ask you a question?
You can, I don't know if I can answer it. Go ahead.
You said something about a bond.
Right. I'm gonna get a bond report from probation. I can't set the bond without getting that bond report. So if I get it before March 21, I'll set it for hearing. If I don't, we'll try and take it up on March 21, okay?
Yes, Your Honor.
Cost coming on for alleged violation of alternative community corrections. Defendant appears in person from the Elkhart County Correctional Facility as a self-represented litigant via WebEx. State of Indiana appears by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. Court conducts preliminary hearing regarding alleged violation of placement at Michiana Community Corrections. Defendant requests appointment of counsel. Defendant examined found to be indigent. Public Defender's Office appointed to represent the defendant. Court orders probation to prepare and file with the court a written bond report. Court will set this matter for hearing on bond upon receipt of that report. Court orders Elkhart County Community Corrections and Michiana Community Corrections to file eligibility reports with the court. Court resets this matter for further hearing March 21, 2024 at 8:30 a.m. It is so ordered. I'm going to see you back here March 21, if not before. Okay, Ms. Hodges?
Thank you, Your Honor.
Listen to me. You made a very good decision. I know you don't feel good about this. You made a good decision. You representing yourself was going to be a disaster. You're too emotional right now. You need to get a cold-blooded attorney in there to talk to you. You'll be fine. They'll be cool. They'll
Thank you, Your
represent
Honor.
you well. Yeah,
Thank
good.
you.
Good luck.
Thank
How
you.
about Elizabeth Hall? Elizabeth Hall?
Megadeth, Treasure X, and Jane, thank you so much. I don't even know what to say. Thank you. So that's the kind of day this judge is having. He's having a day. We're gonna step away from him for a minute, but then we'll be back. Yeah, a cold-blooded attorney. Cloud, you got that? I did too. That's so funny. All right, we're gonna go to YouTube and we're gonna go to Washington.
Anything, you can call it. We're just waiting for the councils.
Yes, we can take Holly Louisa on the 9 o'clock. It's for a benchmark flash calendar.
Hi, good morning. Good morning.
And for the record, Sean Parent from Ms. Louisa. This is 2A0298380.
Everything is slow in Washington.
You know, there's a lot going on this case, so in my consideration of quashing the warrant, I want to look at the various probation issues that have been outstanding.
I have a probation meeting right now at 11 also. That will all be squared away.
That's in Shoreline.
It's in Shoreline.
All right, so Mr. Mitchell, my probation officer had alerted the court that there was a dirty UA and non-compliance with treatment and swapping out treatment providers. So there was a number of things that were going on with the probation piece. I'll hear from Ms. McDonald.
Pull up her case here.
May I say something about this? When I was changing treatment providers.
Yeah, sure.
Just so I would like to explain something to the court.
And then I want to hear from Ms. McDonald.
Oh, okay, go ahead. I'm sorry. Whenever.
So just give me a quick second here. So, all right. I don't know that I have the 229 notice of violation. I did see that in the docket. I looked through my emails and I wasn't seeing it. I know that she had medical complications and surgery on her back. At least that's what was expounded to the court at the last hearing. But I am concerned about the lack of communication it looks like we're having with the treatment agency and the lack of otherwise compliance, whether that be online or virtual meetings, things of that nature. So certainly would like to hear the status of what's going on there.
Let me ask, you did not get the notice of violation?
And there we know. There I stopped what I was doing. This judge, Jennifer, is mad. She is really mad. I knew from that one question that she is ticked off. Not at Carmen. I guess Carmen's supposed to have this, but she doesn't. But she's not mad at Carmen. She's mad at this lady, and she's really mad.
I don't see that I did.
I signed it off. I signed off on this notice on the 28th of February. It was presented to me.
Sure.
We can have it scanned, but there was a fentanyl detected January 18th. There was a 226 report from client services provider that she had restarted with a different provider. So I think there was one provider, then switched to a different, then went back to the original.
And I think my question is the positive UA that we got for that, or the positive for fentanyl. Did she have a prescription for that following her surgery? Because I know that kind of complicates things.
No, and that's why, no,
I think that was the issue, that it was a non-prescribed substance.
No, but I never took it. And now they've done all of my UAs and they've never found that. That was just a fluke.
I don't know what that means, since they found it, which is why it's on the notice.
It was a mistake. It was something went wrong with the lab.
Mm.
I've never taken any drugs but when I'm prescribed.
Same.
I'll go and take one right now. I mean, I don't do drugs. I only take what's prescribed to me.
Mm-hmm.
And I'm in complete compliance. What happened with the reason why they were switching me is they thought it, because of my surgery, that it'd be better if I moved over here. And so then they told me that I could go to a provider over here, and I couldn't get into the one that they said until May. And so I tried to get back in to the one up on the 15th, but because they had that UA, and I went back to that other one because I've already done everything with them. But I am not the one that tried to switch my providers. It was them that were trying to make it easier on me to have.
Well, Ms. Loaiza, in the prior hearings, there's been a number of reports in which the gal you were working with at the treatment provider would say that you would contact her and then want that to be like in compliance. And she was letting the court know that that was in no way a meeting that was set up in compliance. So, from my perspective, what I've been receiving is that you're not in full compliance. It's been a long road of being out of compliance with this marginal and coming in and excuses.
No, I'm not making up excuses, and I have been in compliance, and you have received a compliance report for this month, last month, that I am in full compliance.
Hold on one second, please. Officer Hanson, who did we get today?
Yeah. The Nichols. And Ms. Relena Miller, Ms. Smith had court elsewhere, and Mr. Huico refused.
All right, thank you.
So I heard Huico refused and Smith had court elsewhere.
We did get Miller and Nichols.
Miller and Nichols. Okay, perfect. Thank you.
All right, so I'll hear from Ms. McDonald on the city's position.
Well, Your Honor, honestly, I'm not necessarily buying that. I mean, if they detected fentanyl in her lab test, then I think that's, unless she's got something else from the treatment agency to say that there was some sort of interference or something otherwise with the lab test, I have a tendency to trust the treatment provider and the lab provider. So I think we're looking at a revocation here. I would object to quashing the warrant and ask that she be remanded today pending that review hearing, given the presumption and the standard of review here being what it is. I think the court can certainly find probable cause that there is a violation of her conditions of sentence, remand her into custody, and set for formal review.
I have a doctor's appointment, and I'm today at 1. I mean, it's really important I go to the doctor's. I'll die in the hospital. I mean, if I get reprimanded, I'm in full compliance. I promise, I swear to you on the Holy Bible, I am.
But you have not been in full compliance. That's what we've heard over and over from you, but the thing is, you haven't been. But every time there's something that's wrong. You might be in your mind in full compliance because you just started brand new treatment and maybe went to a couple sessions in the first couple of weeks, but that's not really.
I'm in the very
in the spirit of things, being in full compliance with what's expected of you.
Okay, I understand, and I want, please, Your Honor, let me just prove to you that I will do everything the way I'm supposed to. If I go into jail with my back on the cold floor, it will give me permanent damage to my nerve system, and I'm going in for nerve surgery. I have an appointment at 1 p.m. I can show to you. I apologize that everything that's happened, but I have faced a lot of surgeries. I've had 2 very serious surgeries since this has been going on, and so I am sorry if I've stumbled through this whole court thing. I've never done this before, but right now I am in compliance. You have a compliance report that was sent to you that says that I'm in full compliance. And I don't do drugs.
And Your Honor, I'm not sure if we touched on the reason for her failure to appear, that she did have a treatment session that she had to go to.
I was at a treatment session with my provider at that time. It's in the report also. It should be showing that that's when my one-on-one appointment was for them. And I couldn't be at both places at the same time.
Her defender probably could have gotten her out of
From
this.
the defense perspective, it does seem
mouth.
unusual that someone would test positive for fentanyl and then never test positive for it again. It seems to be more in line with a fluke than someone who's an active fentanyl user.
I don't think she's an active fentanyl user per se.
I beg you, Your Honor.
Let's see, I have. I'm looking at the packet that I have here. So for the month of December, was out of compliance. I'm trying to find the documentation that you say is here that you're fully compliant.
I have it on my phone. I can send it to you. Charles Mitchell's received it, and I talked to him on Thursday, and he said that he did have it.
Mhm. Right, and he's the one that put in that you're out of compliance with your probation. So that I'm getting information from Mr.
But that's the probation and shoreline that I'm fixing right now, that I have the appointment right now at 11 o'clock. And then I will be fully in compliance with them. If you take me into custody, then I can't go to my appointment. I have my appointment right now at 11, and then at 1 o'clock, I have an appointment with my surgeon in Issaquah. They're killing the nerves in my back now. And if you want to talk to Nicole in probation at Shoreline, she'll verify that I have an appointment with her right now at 11. I'm doing everything I can to try to do everything the right way. And like, I'll repeat myself again. If I haven't done everything the way that it's supposed to be done, I'm 54 years old. I've never been in trouble before in my life.
Ms. Lueza, we've made it abundantly clear what you need to do.
I understand now.
Okay,
but
so
I
it's
think
not it's not that confusing.
it is
It
when you
means
take
that
the
you need to
medications.
communicate with your probation officer, and you need to do the things that are expected of you. And I don't think it's that hard. You've made it incredibly hard, and you've manipulated a lot. And that's what the court gets reports from your treatment providers, that you're very manipulative and you're trying to game your compliance. And it just doesn't work that way. You don't get to set the rules and then come in and say that you're fine. Everyone else is held to a high standard. I expect the exact same of you.
Okay.
You're on a deferred prosecution. That's an incredible opportunity for you to have this removed from your record. And so I expect you to follow through. Now, I have empathy that you have medical issues, that you have back pain. I get that. But what you have shown me over the months is that you will not do what's expected of you. You fall out of compliance, then you get marginally back into compliance. You pick and choose your programs. You're telling Mr. Mitchell something, and then you're saying that you're a counselor and that you talk to her, and she'll say you call, but it's not a session. So what I'm getting is that there's little bits and pieces that you come in and try to make excuses for things. And so that is my problem. And Ms. McDonald is saying that you need to go into custody and wait out a review hearing. That's what the city wants.
Can you please let me go and get in compliance with my probation officer? Go to my doctor's appointment, and I promise you that I will make sure that I follow everything exactly. I'll have it on a calendar. It's just that I had, with the medications was taking after surgery, I was getting confused, and that's not an excuse. It's just a reality.
Fentanyl does that.
Days would slip by.
Okay. Ms. Lueza, what's somewhat indicative of what's been going on in this case, you currently have $40,000 bail that's been posted on this matter through numerous incidents that we've had to go through. That's a lot of bail.
But it was only one that was 25,000.
Well, and a lot of smaller ones. And
there was just 2 that were posted.
No, there was 25 and a 10 and a 5.
And that was because the ankle bracelet wasn't put on, the $25,000 one, that I couldn't find it in time. It's not because I've done things to be vindictive. I've never wanted to be vindictive or try to take the court and not be in compliance and try to trick anyone or anything. It's just circumstances in my life with my back pain is just excruciating.
I suspect everyone who's sitting in here has a lot of things that they'd rather be doing, and they will wonder why you would be given an opportunity to skate by with all these excuses.
I'm not asking for to be an opportunity to skate by. I'm asking for the opportunity to prove it to you.
Ms. McDonald, I'm thinking of setting this for a formal revocation hearing on, our next date would be the 13th for a calendar, or we could special set it for, well, I guess that would be the only time. We could do this Wednesday, but that's probably too short a period of time for council to get up to speed on this.
Well, council to get up to speed on that, and we may need to have someone from her treatment agency up here as well.
On 3/13, we could set an afternoon revocation hearing.
What does that mean?
So
And I know we have a motion
so
set.
the hearing
You have a motion set on the 13th?
would be
Yeah.
sanctions on the case. So
We could do it the afternoon of 3/13. Yeah.
he'd be out of custody.
Can I do that through Zoom?
No, he'd have to do it person.
And what is our motion on 3/13?
Can I do, is that the only date that they'll let me do it? Because I'm leaving to go to Florida to see a specialist for my back.
Oh, when?
I leave on Wednesday and I get back the 27th.
What time do you get back to the 27th?
I get back at the 27th at like 10 o'clock at night.
Okay.
But I'm going to see a specialist
So,
because
so
right now
when do you leave? Oh,
I leave Wednesday.
this Wednesday?
Yeah.
So on next week, Wednesday in the afternoon, we have Kennedy. It's a jury. It was set for trial and.
Looks like the defense wanted to have witnesses from the Michigan deal.
Yeah, I mean, I guess I could change my.
Okay.
Instead of going to
Is that-
custody.
Is that a public defender case? Do you know Mr. Kennedy, Michigan DOL motion hearing?
Oh. Yeah, and that one so they're suspended out of the state of Washington too. So I don't think that that's necessarily going to be an issue.
Okay, so we will
Okay.
have that afternoon blocked to do this hearing.
So Ms. Loaiza does want the court to know that she's leaving this Wednesday to go to Florida to see a specialist for her back, you said?
Yeah, it's for surgery, to do laser surgery on my back instead of having right now. I'm scheduled for a series of 3 surgeries starting on the 28th of this month. And then the first 2 are 15 days apart. And then the third one's in May, which they'll go in and burn all of the nerves in my back. And so there is a doctor out of Florida that I have an appointment with who is a laser specialist, that it's a non-invasive surgery that but I have to go and do a stand-up MRI with him instead of laying down MRI. And then he'll evaluate me to see if I'm a candidate to do the surgery with him, which that would be non-invasive. With the 3 surgeries that I'm scheduled for right now are invasive surgeries. And my body is very tired of all. I've had 16 procedures done on my back. I've had, and that they go from.
I've understood that you've had issues. I'm not going to allow you to go out of state to go do. You're going to have to stay here and answer to this revocation. You're on a deferred prosecution. Yeah, that's not gonna happen, Ms. Loaiza. Right now, I'm considering whether I'm taking you into custody, or actually I'm going to, I'm not gonna quash the warrant. You can either post that bail amount or you'll be taken into custody. I'm gonna set this for a formal hearing for next week, Wednesday.
And how much is the bail amount?
And what's the bail amount, Your Honor?
I think it's 2,500. Let's confirm that. And that was for not appearing for your scheduled review and not calling in. And that's one of the things that, well.
I did call in the same day. I spoke with you and I spoke to Mr. Mitchell's about it. I talked to the lady at the counter, and then I also talked to Mr. Mitchell's about it.
I'm taking a shot for every one of her excuses, but I didn't invite you because I'm not a murderer.
actually on the date of the warrant. It was set for the 28th. You did not appear. You called after the calendar was over. The warrant had already been issued. You said you thought the hearing was the following day.
That is true. I was confused
Right, and
about
you've been in this court for a number of years now. We've never had a court on a Thursday for you. We have Monday and Wednesday.
That's where I get confused. I got confused with the one in Shoreline because it's on Thursdays, and I apologize for that. The medication does make me confused.
Right, and then I think we had another incident where you had went to Mexico for some medical care, and there's just a whole lot going on with your case, Miss Louisa. So I'm going to maintain the bench warrant. You can post or you can be taken into custody today. We're going to set this for 3/13 at 1:30 for formal revocation.
What day was that again? The 13th?
13th. So that would be our next week, Wednesday.
At 1:30?
Yes, let's do the 1:30 since it doesn't seem like we have a conflict.
And if she doesn't post the bail and she is taken into custody, are we going to have transport at 1:30 or are we going to try to do that in the morning?
Our morning is full, so she would have to come in the afternoon where we could give her, the amount of time necessary.
I will post the bail right now. I can get money, that's another.
So you can post that bail and then your hearing will be set for next week, Wednesday.
Mm-hmm. I can get it from a friend.
Okay. Ms. Louise, I don't want to see you in custody. I just want you to do the things that have been asked of you.
Sign there.
Right here?
Down there.
Do I give them the money at that front counter or how do I do that?
Yeah, it's press it.
Okay.
So the bill, is it 10%? Or how does that work?
If you go to a bail bonds company, it's 10%, or you just post the entire cash.
Okay, I'll do the bills bond. Then can I do it out in the hallway or how does that work? Okay, thank you. And so can I talk to you over the phone about what to expect
For sure.
for this?
For sure, yeah,
Okay.
absolutely.
Not so fast.
When would be a good time for me to talk to you?
I think something later this week. Maybe even Wednesday.
Wednesday mid-morning. Absolutely. Okay.
All right,
Thank
Holly,
you.
thanks.
Ms. Louisa, please have a seat against the windows.
But I was gonna get the bills bond into.
Right. The officers are going to come in here. They'll allow you to make bail. They're not going to book you. They're going to give you an opportunity to do that, but you're not free to leave. So you can have a seat there and they'll come in and assist you.
They'll assist you.
You have.
Yep, she didn't go home that day. I don't know. I don't know if she posted bill or not because we don't get to see that. I mean, her friend probably did. Who knows? But yeah, she couldn't come the one time because she was in Mexico for a surgery. Now she's going to Florida for a surgery. And she called and spoke to the judge, or she spoke to the lady at the front counter, and it was just excuse after excuse after excuse. And now I'm drunk. Okay, there's another lady. We're moving to another lady, but we're going back to Indiana, who just doesn't understand what's going on.
Yes,
State your name.
Adriana Woods.
Show the defendant appears in person by her attorney Mackenzie Bowling, both by WebEx. State of Indiana in court by Deputy Prosecuting Attorney Don Pitzer and Robert Swaby. Status conference. Go ahead, Ms. Bowling.
Thank you, Your Honor. We've signed and filed a plea agreement prior to this being transferred. I'm unsure as to whether or not the court would like me to execute a new plea agreement or if you are fine with proceeding on that agreement. That was on December 14th, I believe it was filed.
I've got it. Ms. Woods, is it your intention to plead guilty this afternoon?
Yes.
And you're going to plead guilty to?
Sorry about that. This
That's the
judge,
level.
he talks really, really, really fast all the time. And now all of a sudden he was talking really slow, and I thought I messed up the speed. I thought I had knocked the speed down to like 50%.
6 felony, is that correct?
Yes, sir.
Did you hear the rights that I described earlier to people who are pleading guilty?
Yes, I did.
Did you understand those rights? Are you waiving those rights? And are you pleading guilty without a trial?
Yes, sir.
Is this your own voluntary decision?
Yes, sir.
Let's go back to May 11, 2023. On that date, were you in Elkhart County, state of Indiana, and did you knowingly exert unauthorized control over the property of Walmart with intent to deprive Walmart of the value or use of any part of that property?
Yeah, yes.
What did you take from Walmart?
I attempted to take a few things, food, nails. My friend had it in her bag, but she threw it. And Walmart, I'm mostly positive they received all their the stolen stuff I attempted to take. I'm pretty sure they got all that back, but.
Okay, Ms. Bolin, you want to try? Because so far we got no factual basis. Go ahead.
Yes, thank you, Your Honor. Adriana, on May 11th of 2023, were you in Elkhart County, state of Indiana?
Yes.
And on that date, did you knowingly exert unauthorized control over the property of Walmart?
Yes.
And you did so with the intent to deprive Walmart of the value or use of said property, is that correct?
Yes, ma'am.
And like you just represented to the court, it was food and some other things, is that right?
Yes, ma'am.
And you have a prior unrelated conviction out of Elkhart Superior Court 6 under cause number 20D06, 2209 F6 1203, is that right?
Yes, ma'am.
The court satisfied with factual basis, Judge.
Did you take the property without the consent or authorization of Walmart?
Yes, sir.
I'm interested. Did you get the items outside the store?
We was in the parking lot, and my
There you
friend
go.
threw the.
You got outside the store and passed all the points of checkout to pay for the items, correct?
Yes.
Yeah, quit mitigating it. You either want to plead guilty or don't. If you don't want to plead guilty, Ms. Woods, don't take the deal. Do you want to plead guilty?
No. I'd like to go back. No, because they did get all their stuff back.
That
They
doesn't
received all
matter.
their stuff.
That doesn't matter, Ms. Woods. That doesn't matter under the law. That goes to
Okay.
mitigation and restitution. You want to go to trial? I'll hear a trial on it. I'll get you a jury trial and you'll have a trial. You're going to get no benefit of a deal. You need to understand that. Okay. No.
Okay, I'll
Nope.
plead
Nope.
guilty.
Nope. Okay, that's fine. Please reject it. You can start all over. Let me see if we've got trial dates. We do. You're set for jury trial June 17, 2024 at 8:30 a.m. Do you acknowledge that on the record?
Yes.
You
Yes,
understand? If you don't show up for that jury trial, the court's going to hold the jury trial without you.
Sir, I'm currently in Alabama living.
Well, good luck. It'll be a nice trip up here, won't it? If you don't come to the trial, stay in Alabama. You don't have to come to your jury trial. I'll hold the jury trial without you. Do you understand that? That's my question. Do you understand that?
Yes, I do.
So if you want to tell your side of the story, you want to call witnesses, you want to present evidence, you better be in court for your jury trial on June 17, 2024 at 8:30 a.m. Do you understand that?
Yes, I do.
Your trial status conference is going to be May 16, 2024 at 8:30 a.m. I'm confirming that. I want you to appear in person for your trial status conference.
Yes, sir.
You talk to Ms. Bowling. Maybe she can get you convinced that you should plead. I don't do that. I'm the judge. Mr. Swaby, you got anything
Okay.
you want to add?
No, Your Honor.
Cause coming on for status conference. Defendant appears in person and by her attorney, Mackenzie Bowling. Both of them appear via WebEx. State of Indiana appears by Deputy Prosecuting Attorneys Don Pitzer and Robert Swaby. At request of defendant, court rejects plea bargain agreement. Defendant acknowledges jury trial setting on the record. Court confirms the trial status conference date of May 16, 2024 at 8:30 a.m. and orders the defendant to appear for the trial status conference in person. It is so ordered. I'll see you back here on May 16th. Good luck, Ms. Woods.
Thank you. Have a good day.
She really believes that because they got all the stuff back, that she didn't steal anything. She maybe attempted to steal something, but yeah, they got it back. So yeah, I didn't steal anything. They got their stuff back. Now this next guy, he learns real quick who's the judge in this courtroom.
Yes, Your Honor. Same here. Bye-bye.
How about Michael Carter? Michael Carter, you there?
Yes, I'm here.
Okay, hang on a minute, Mr. Carter. Come on. CL1 2402 F6 235, State of Indiana versus Michael D. Carter Jr. Mr. Carter, raise your right hand. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yes.
State your name.
Michael Deron Carter Jr.
Show the defendant appears in person from the Elkhart County Correctional Facility via WebEx. State of Indiana in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. Mr. Carter, let me have your date of birth, please.
03/02/1992.
Got it. Thank you. You're in court for an initial hearing as a result of the State of Indiana having charged you with intimidation, level 6 felony. It reads as follows. The affidavit, the probable cause affidavit filed here with swears that on or about January 8, 2024, the County of Elkhart, State of Indiana. One, Michael D. Carter Jr. did communicate a threat to Melanie Godden with the intent that Melanie Godden be placed in fear of retaliation for a prior lawful act, and the threat was communicated to Melanie Godden because of the occupation, profession, employment status, or ownership status of Melanie Godden, all of which is contrary to the form of Indiana Code 3545-2, 1A2, and B1C, contrary to the form of the statute in such cases made and provided and against the peace and dignity of the State of Indiana. I will enter a preliminary plea of not guilty for you at this time. The, excuse me, the penalty for a level 6 felony is an advisory prison term of 1 year, can be increased to 2.5 years for aggravating circumstances or reduced to 1/2 year for mitigating circumstances, and you can be fined up to $10,000. Did you hear the rights that I read to other people who faced a level 6 felony previously? Were you present for that?
Yes, I was.
Did you understand those rights?
Yes, I do.
Thank you. Let's set some hearings in your case. Well, first let's find out. Are you gonna, hang on a second.
Fast and speedy trial.
Okay, so here you go. You want to yell out and you want to talk when I'm talking. If you want to do that, you're going to get held in contempt of court, and I'm going to put you at the Elkhart County Correctional Facility for up to 180 days. That'll be without good time credit. That's regardless of what happens in the criminal case. Please don't do that. I'm going to wait to talk to you and respect you. You've got to respect me. Will you do that, Mr. Carter?
Yes, I will.
Now, you're screaming about a speedy trial. I want you to understand something. In my court, everything's filed with a written motion. So you don't make oral motions. During trial, you make oral motions, but otherwise you do written motions. Okay, so let's start with this. Are you going to represent yourself? You're going to hire private counsel? You want a public defender? What's your pleasure?
From my concern, I already had a public defender represented to me, which is Matt Johnson. So I don't know how you're going to proceed with that. He's already represented me for several cases, including the level 4 offense that I'm charged with from the same day of January 8th. So I thought that this was going on with this same case.
It may, just hang on, it may, but it got filed separate. Let's you and I get everything on the same track. I mean, I think that's what you want, because I think it's best for you. I think you realize that. That's what I want to do too. So let me ask some questions. You want a public defender. If I ask you the same questions you were asked before, relative to your income and assets, would your answers be the same?
Yes.
Court finds the defendant to be indigent and appoints the public defender to represent the defendant. I don't run the public defender's office. I would think it's likely going to be Mr. Johnson. That just seems logical to me, okay? I'm going to set, hang on a minute. I want to look at these other cases. Mr. Johnson, you may have to help me out. But
Your Honor, we are set for evidentiary hearings on March 13th for the violations. So we'll be back here with Mr. Carter on that date.
yeah, but I'm looking at the others. Do you want this to get set? The 2401F4 isn't a violation. That's a new case. That's the case he's talking about.
Right.
Do you want, what are those dates? I don't have those dates down. Hang on a minute.
I don't have them with me either.
Well, I'm going to try and get them up. Just hang on a minute. Let me see. Because it might make sense that we try to do that. Keep everything on the same page. Well, yeah, so of course I don't. Here we go. I show the jury trials being October 21, 2024 at 8:30 a.m.
Yeah, I think at this point, what we can do is set it together with the F4, and we'll start dealing with all these things.
Well, and you know this, you guys can always sort this out and tell me what order you want to do things, and I'll change it.
Yeah.
Okay, so I'm going to go kind of backwards on, well, I'll go forwards on this. You're coming back March 13. Do you want to do the pretrial conference that date also?
That would be great.
Don't you think?
That's fine.
I'm going to try and get these cases coordinated so when you're in court, you're going to be in court on almost everything, Mr. Carter, so you don't have to come back on each case every time.
Is I'm allowed to speak now, Your Honor?
No,
Mr. Carter, I'll be out to see you before your hearing, and we can talk about everything all at once. That's the right answer.
Okay, so let's do the pretrial conference, March 13, 2024. Did I set it at 8:30?
Yeah, it's a 2.
At 2?
Yep.
At 2:00 p.m. The omnibus date is gonna be still April 25, 2024. And now, let's get to trial status conference. I'm showing this to be September 26th. September 26th, 2024.
At 8:30 o'clock.
At 8:30 o'clock a.m. Last but not least, the jury trial is October 21, 2024 at 8:30 a.m. Now, Mr. Carter, do you acknowledge on the record this case has been set for jury trial October 21, 2024 at 8:30 o'clock a.m.?
You said what date?
October 21, 2024 at 8:30 o'clock a.m.
So that means that you combining all of my cases together? That's what
I'm trying to get them all set at the same time. That doesn't mean they'll all go to trial on that date, but at least when you're in court, you're gonna be in court for all the cases on one date instead of coming back 4 separate dates.
including my probation violation?
I think
your
that
probation violation is gonna be still on March 13th.
Yeah, that's set for March 13th.
So
coming up real soon.
But I still be able to request for my fast and speedy trial on my new cases. That's what I'm not trying to get confused.
That is, Michael, that's something that we can talk about.
Okay, but I just don't want to acknowledge a trial date, and if I want to ask for a fast and speedy trial, that's all I'm saying. I don't want to acknowledge that I'm willing to go understand that you're setting my trial date to September in both of my cases when I was trying to ask for a fast and speedy trial.
Michael, as your attorney, I'm telling you, you should acknowledge the trial date. We will get the information on the new case, and if it's appropriate to do a fast and speedy, that's what we can do. But that's
okay. I'm gonna acknowledge this is on record that I'm gonna go with this, but I'm still want to acknowledge on record that
Mr. Carter, stop talking. I'm tired of waiting for you to have a consultation with your attorney with me present, which is totally inappropriate. Totally inappropriate, Mr. Carter. Not just for you, for me. So I'm going to handle this another way. I'm not going to ask you to acknowledge it. Listen closely. I'm advising you, your case is scheduled for jury trial October 21, 2024 at 8:30 o'clock a.m. I'm advising you that if you don't show up for that jury trial, your jury trial will occur without you. I'm advising you that if you want to tell your side of the story, you want to call witnesses, you want to present your evidence, you're going to need to be in court for your jury trial on October 21, 2024 at 8:30 o'clock a.m. Now, one final thing. What about bond? Do you want me to get a bond report ordered? Mr. Johnson's shaking his head yes. Do you want to overrule that too, Mr. Carter?
No, because you already denied me bonds in my other cases. I'm for sure you're gonna do it in this case too, so I just really ready to proceed with the matter.
Great idea.
No bond report. Cause
Smart
coming on
thinking.
for initial hearing. Defendant appears in person as a self-represented litigant from the Elkhart County Correctional Facility via WebEx. State of Indiana in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. Court conducts initial hearing. Defendant requests appointment of counsel. Defendant examined and found to be indigent. Public Defender's Office appointed to represent the defendant. Court schedules pretrial conference for March 13, 2024 at 2 o'clock p.m. Court schedules omnibus date for April 25, 2024. Court schedules trial status conference for September 26, 2024 at 8:30 o'clock a.m. Court schedules this case for jury trial on October 21, 2024 at 8:30 o'clock a.m. Court Court advises the defendant of the jury trial setting on the record. Court advises the defendant that if the defendant fails to appear, the jury trial will occur without the defendant being present. Court denies defendant's request for a speedy trial because the motion was made orally and not in writing. It is so ordered. Thank you, Mr. Carter. I'm going to see you back here March 13.
Yep, there's Indiana. We love Indiana.
Your Honor, same here.
Oops.
Bye-bye.
They do great. They do great work. I didn't get a lot from Colorado because it was kind of boring today. It was kind of boring today in Colorado, so I had to look to Georgia and I had to look to Indiana to save us. He's always good because his days are long. Like it's 9 hours every day. Other judges, you have to catch them when they're on, and they're only on for an hour here and an hour there, and they only work Tuesdays and Thursdays or whatever. This judge works every day, 9 hours a day. Oh, Kelly, I hope they were good ones. I hope they were good cases. I hope you're not doing it for like your job or something, because that would stink. I got a lawyer that comes into the bar all the time, and I ask him questions, and he never answers. He always fakes answers. Like, yeah. Like he'll agree with my question, but he won't answer the question. And I don't ask him anything that could be even slightly perceived as legal advice. So I know you're not allowed to do that. But yeah, I think this judge, I think he likes his job because he's very proud of how close to the law he sticks and how he treats everybody the exact same way. So, yeah, he's a good fallback judge for me. I like him. Judge Boyd, I don't know why it's hard for me to watch her. I don't know why. From the beginning, it was always hard for me to watch Judge Boyd. I loved her bags, I loved her flowers. But I don't know. I have no idea what it is. She does a great job. But all right, guys, that's all I have for today. I really appreciate y'all coming out. Thanks for the super chats and the memberships. I appreciate that so much. And I'm going to get ready because the courts are about to open. You too, Cloud. You guys have a good day.